focus mom, Kim, and she is over at Harrison and Held currently. Kim, take it away.
Okay, well, thank you. So today's talk is called Turning 18 in Special Needs Land. And Jade and I kind of brainstormed this because there are so many things that happen when your child turns 18. That's mostly what I'm going to be talking about today is the age of 18, but we'll go beyond that in the later part of this talk and talk about some of the ages after 18 and some of the events that happen later in your child's life that are also kind of landmark things to pay attention to. So a little bit about me. As Jade mentioned, I'm a focus mom. I have a son who is now 16 years old, and his name is Finn, and he was diagnosed with autism when he was about 2. So we have been going to the Saturday respites and the focus camps and all of those great things for a long time. Sometimes I feel like I spend more time talking about Finn than I do about anything else when I meet with parents. But as we were just saying before we started recording, that's part of the fun of this job is that you get to talk about your kids all day. So I have credentials up on the screen and you can read them if you want to, but I really think my greatest credential is that I'm Finn's mom, and I am a special needs attorney. So my entire practice is devoted to special needs planning, guardianship and conservatorship, and I do some consultation with divorce lawyers who are working with a family that has a special needs child. So that is what I do. Before we get started, I have to do my little disclaimer here. The purpose of this meeting is educational only. So nothing that I say today is legal advice, and you should not take it as legal advice. Any opinions that I express in this talk are only my opinions. I am not speaking on behalf of any official organization of the state or county. And this meeting, while it's intended to educate you and give you some resources, it is not a substitute for a meeting with an attorney who knows your specific facts and who can give you advice based on that information. And before we really get rolling, I just wanted to ask everybody to sort of, in addition to taking notes, hopefully, and learning something, I just wanted to say before we get started, I love speaking in front of special needs parents. They are my favorite people in the world. I have so many friends who will not be told no when it comes to their kids. And as moms, we bully doctors and we fight with school systems. We move mountains for our children. And we also have such capacity for patience. I have spent 16 years learning how to be a special needs mom. And I've come a long way since the day my son got that autism diagnosis. But I will admit to you that I have one habit that doesn't do my son any good, and maybe you have it too. Every time I find out about a benefit that Finn could be qualified for or a program that he might like to do, I blame myself for not knowing about it sooner. I'm a special needs lawyer. I do this all day. I'm supposed to know everything. So it's hard to remember to give myself a break. So for the next hour, let's all just be in a judgment-free zone. Let's recognize that we're doing a hard job and we're doing it the best we can. And if you hear something today that makes you think, oh no, I'm behind, I should already have done this, I should have done it a year ago, just forgive yourself. It's okay. You can do it now. So with that being said, we're going to start this talk with a to-do list for the things you should do when your child turns 18. The first 2 are really easy. They're just one quick little slide each. The other 2 are going to take a little bit more time and talk. But the very first thing that you can easily do, if you have a male child only is register your child for the selective service. There is no exemption from the requirement to register your child for the draft. So a lot of people don't know that, but you are required to register any male between the ages of 18 and 25 for selective service. Now, if there actually is a draft, that's when you can claim a disability exemption for your child, but he does need to be registered. And the way that you could do that, there are a lot of different ways. You can go online, and I have the website up here, sss.gov. There's a form that you can print if you don't want to register online, or you can go to the post office and you can get SSS Form 1. You can do any of those things. And by the way, all of these websites and other things that I'm going to post in these slides, they're all collected in a PDF, as Jade mentioned, and she is going to have a link to that PDF that'll give you all this information. So if you don't get to write something down quickly enough or something, don't worry about it. You can just go to Focus and there will be a link for you to get all these websites and everything. So it's a big deal if you don't register your child. If you get caught not registering, there's a $250,000 fine and or 5 years in prison. Hopefully that's not going to happen, but the easy way to avoid that is just register your child for the draft. It's no big deal. Then another thing that your child becomes eligible for, very likely at age 18, is what we used to call food stamps. Now it's called the SNAP program, Georgia Supplemental Nutrition Assistance Program. So in many counties in Georgia, there is a work requirement to qualify for SNAP. But if your child isn't able to work, that requirement is waivable. You just need to demonstrate that your child has a disability that makes it impossible for them to work. Your child has to have net income below the poverty line. And the reason that age 18 is significant here, by the way, is that at age 18, that is when your child becomes a household of one for the purposes of all the benefits that we're going to talk about. So that's also the reason that most of our kids don't qualify for SSI, which we're going to talk about at length later, until age 18, because until then, the family resources are attributed to the child. But at age 18, your child's net income needs to be below the poverty line. I think that's $12,800 or something this year. And there is a means test for SNAP benefits, just like for SSI, but the means test is actually a higher number for SNAP. So if your child has assets of less than $3,750, then they pass that asset test and they'll qualify for SNAP. The greatest amount that you can get in SNAP benefits is $250 a month, but they're going to do some math based on any assets or income that your child does have. So there's a formula. So it could potentially be less than $250 a month. They're just going to give you a little debit card. It looks like any other debit card or credit card. And it'll have $250 a month or whatever amount it is that your child qualifies for on it. So that's how that works. And there's information on this slide about where to go to apply. And a phone number for the customer contact center. Although I tried calling the phone number and I was on hold for 20 minutes and finally gave up. So if you want to take a shot at that, you can. I am not promising that anybody's going to answer. So those were two quick, easy little things that I got out of the way quickly, because one of the big things that happens when your child turns 18 is that legally your child is an adult. Even if they don't really have the capacity to take care of themselves or make decisions for themselves. And so for that reason, a lot of parents, when their child turns 18, decide that they want to petition for guardianship and or conservatorship. And if you don't do that, then legally your child has the same capacity and the same rights and the same responsibilities of any other adult who is 18 or over. So guardianship, as opposed to conservatorship in Georgia, these things have different names in different states, but in Georgia, Guardianship is the name that we give to care of the person, which means making medical decisions, deciding where the child's going to live, just generally making decisions that will keep your child safe and happy and living his best life. And in order to argue that your child needs guardianship, what you would be arguing to the court is that your proposed ward, your child, can't make or communicate significant responsible decisions about his own health or safety. Conservatorship is the other side of the guardianship coin. Conservatorship is care of the person's assets. So guardianship is essentially parenting. It's making sure that your child is safe and happy and has proper medical care and all the things that you do every day now. Conservatorship is managing your child's assets under the conservator umbrella. So you become a fiduciary whose job is to take care of your child's assets. You can't spend the assets without permission from the court. The court does not like to see anything but very safe conservative investments. I mean, they basically want you to have your child's assets in a money market type thing. Because they're supposed to be liquid and available to take care of the child. So you don't have to petition for both guardianship and conservatorship. You petition for conservatorship if your child actually has assets. So if your child has money in a bank account, if your child has income from a job, then it would make sense to petition for conservatorship. And again, you would need to demonstrate to the court that your child can't make or communicate significant responsible decisions concerning the management of those assets. Not all assets are subject to conservatorship. So if your child has no assets in the bank and no earned income from something like a part-time job or something, but your child has income from SSI, as long as we have a representative payee for the SSI, then the SSI is not subject to conservatorship. And that's because we already have a fiduciary, the rep payee, who's responsible for managing those assets. If your child is the beneficiary of a trust, then the trust has a trustee. And the trustee, just like the rep payee, is a fiduciary, meaning the trustee is responsible for taking care of those assets and managing them the way they're supposed to be managed and using them to take care of the child. So because we have a fiduciary that's in charge of those trust assets, assets in a trust are not subject to conservatorship. So you may or may not need to petition for conservatorship. And these are just some sort of general guidelines to help you figure out whether you want to petition for guardianship and or conservatorship. This is a personal decision that every single family needs to make themselves. So in some cases, guardianship may not be appropriate for your child, but a few questions to ask yourself when you're trying to make this decision are, the first issue would be intellect. Does your child have the capacity to understand things that are said to them? If they needed to, for example, sit with the doctor and talk about different options for a particular type of treatment, could your child sit alone with a doctor and have that conversation and understand what's being said and make a decision? Or would they need help? Critical thinking. Does your child just trust everybody and believe everything that everybody says and do as he is told at all times? Does your child have the ability to understand, this isn't safe, this isn't legal, this isn't a good idea, this person doesn't have my best interests at heart? If they can't, then guardianship might be a good idea so that you can keep your child safe from predators that might talk him into co-signing a loan or doing something else that's not a good idea or not safe. Communication skills. Remember that the standard for determining whether a person should be under guardianship is that they cannot make or communicate significant responsible decisions about their own health or safety. So even if your child is completely capable of understanding what's being said to them, if they have some physical or cognitive barrier to communicating with people, if they use, let's say, the ASL board that helps them to communicate that they need somebody to work with them to speak to the world at large, then that might be a sign that you should seek guardianship over your child so that you can speak on your child's behalf if that's needed. Some parents are like standing at my door 6 months before their child's 18th birthday, which is the earliest you can file, because they have a child who has some type of serious medical condition. A lot of times it's something like a seizure disorder, where at any minute they could be in the emergency room. And those parents have a really great reason to seek guardianship and to do it right away, because once your child is 18, legally, if there is no guardianship in place, the child is the only person who can consent to medical treatment. If you become your child's guardian, then you have the power to consent to medical treatment on your child's behalf. So if you've got a child who is, periodically having to have surgery, or has an issue where they may suddenly need emergency medical care, you don't want to be in a situation where you're in the hospital and you're saying, I want to know the test results, and the doctor's saying, sorry, I can't tell you, because your child is an adult. And then the last thing to think about is how much opportunity does your child have to get into trouble? Not necessarily trouble generated by your child, maybe trouble generated by somebody else. But if your child lives with you and spends 24 hours a day, 7 days a week, either with you or with somebody that you trust to take care of them, maybe guardianship isn't as pressing as if your child maybe goes to a day program or lives someplace other than your home, where there might be an opportunity for predatory people to convince them to do things that are not a great idea. So those are just factors to consider. But as I said, the decision as to whether to pursue guardianship or not is really just very specific to every family. And it's just a decision that you have to make for yourselves. I have done hour-long talks about guardianship, and I just cannot go into any great detail about it today. I'm going to talk about it a little bit, but we have so many other things to cover. This is not a comprehensive talk about guardianship, but I think I have some out there floating around on the web. If you go looking for them, if you want to really hear a lot in depth about guardianship. But briefly, there are certain rights that are going to be removed from your child if you successfully petition for guardianship. So once your child is under guardianship, they no longer have the right to marry. That's for their own protection. We don't want some predatory person to come along and marry your child so that they can become the rep payee for SSI or for some other reason that we wouldn't approve of. Your child no longer has the right to enter into a contract. And again, that's for your child's protection. So they can't be coerced into signing something and committing themselves to something that is not a good idea. Your child will lose the right to decide where to live. So this one you have to kind of take with a grain of salt. As your child's guardian, you can decide where your child will live. You cannot chain them to the bed. You can say, I think that this group home is the perfect place for you. This is where you're going to live. But if your child decides they're going to run off and live under a bridge, you can't physically stop them from doing that. They lose the right to consent to medical treatment. And again, this one has sort of a little asterisk there, because the right to consent to medical treatment is not the same as the right to refuse medical treatment. So while you would be the person sitting in the doctor's office saying, okay, we've looked at option A and option B, and we like option A. This is the course of treatment that we're going to go with. If option A involves taking a pill every day, and your child doesn't want to take that pill, they legally can refuse to take it. And unless they are being involuntarily committed because they're a danger to themselves or someone else, you can't make them take medication. So that's the very first thing under the rights that your child retains. Your child can refuse medical treatment. Your child always has the right to get legal advice and to contest the guardianship if they feel that they should not be under guardianship. They almost always will retain the right to vote. I have seen that taken away one time. I think it was in Cherokee County. And the proposed ward was a very severely intellectually disabled young man, and the judge did remove the right to vote. But most of the time, the court will allow the ward to retain the right to vote. Your child can also have the right to drive and to have a driver's license, assuming that they can pass the test, just like everybody has to. If they have the capacity to make a will, meaning they understand what they're doing, then they do have the right to sign a will. And they always have the right to participate in decisions that concern them, even if you're making the decisions. So these are a few things that I get asked all the time about guardianship. Sometimes parents feel like they want to get guardianship because their child can't be held responsible if they commit a crime. And that's not actually true. Guardianship is not a get out of jail free card. So if your child commits a crime, he can be arrested. And if he gets convicted of the crime, he can theoretically be jailed. I will tell you, though, that if your child is under guardianship and they get arrested or they have to go in front of a judge, for one thing, if you are your child's guardian, then you have the ability and the right to speak on your child's behalf. If you're not your child's guardian, it's going to be your child and probably a court-appointed attorney, explaining as best they can why your child should not be, sentenced to whatever it is that he's been charged with. But technically, your child can be arrested and could, in fact, even be jailed, even if he's under guardianship. A lot of people feel like they have to get their guardianship done before they apply for SSI. That's not the case. Those two things have nothing whatsoever to do with each other, except that they both happen to, be initiated usually when the child turns 18. But you can apply for SSI whether your child is under guardianship or not. You do not need permission from anybody else to seek guardianship for your child. So if your child's teacher feels that he doesn't need guardianship, that makes no difference whatsoever. Nobody except the two people who are statutorily entitled to notice even have to be told that you're petitioning for guardianship, and you definitely don't need anybody's consent or permission. Some parents who have kids who are, high functioning and bright and who have worked really hard for independence have misgivings about petitioning for guardianship because they feel like they're sentencing their child to a life of, not being allowed to function as a full adult. And that's not necessarily the case. So if your child turns 18 and you feel like he still just can't function by himself, he still needs help, he still needs to be protected from people that might talk him into making bad decisions, and then 5 years, 10 years, whatever amount of time goes by, and you've got the meds under control and your child has learned how to function independently and make decisions and express himself in a manner that you feel is just as good as anybody else, or at least good enough so that there's not a need for a guardianship, you can petition the court to undo the guardianship. You can't undo a guardianship because you're sick of being a guardian and you don't want to do it anymore. You can't undo a guardianship because a guardian has died. You can't undo it for any reason other than you believe that the ward now has the capacity to make their own decisions and to look after themselves in a responsible way. But if that is the case, you can undo a guardianship. While you certainly can use an attorney to petition for guardianship, you don't have to. It's not rocket science. You could go to the website or the probate court of the county that your child lives in, and that website is here, or the Georgia probate court website. It's gaprobate.gov. If you go there, it'll have a list of all the counties in Georgia. So you click on your county, and then you go to the forms section, and you're looking for the form that says petition for guardianship and or conservatorship over an incapacitated adult. And the probate court website also has some sort of general information about guardianship and what it is and how it works and how you would need to file the petition. So as I said, I have talks that go on for a whole hour that are just nothing but guardianship talks, and that's where you would be able to find a lot more information about this. But if you're thinking that you might want to do the petition yourself instead of paying an attorney, just go to that website, gaprobate.gov, and check out the petition. It's a form, and that's where you would start. And just FYI, there are filing fees that you have to pay regardless of whether you do this yourself or use an attorney. They vary from county to county, but it's usually somewhere around $700, just FYI. So that's all we're going to say about guardianship, but we are moving on to SSI. That's another big thing that happens when your child turns 18. As I mentioned when I was talking about the SNAP benefits, when your child turns 18, he is considered a household of one for benefits purposes, which is why most of our kids do not qualify for SSI until they turn 18, because until then, mom and dad's resources and mom and dad's income are attributed to the child, because we all have to take care of our kids until they turn 18. So once your child turns 18, even if he lives with you, even if he's still in school, regardless of what's going on, unless he's married, he's a household of one. So the way that you would qualify for SSI is, first, your child has to meet the statutory definition of disabled. And that is that he has some type of a condition that prevents him from engaging in what's called substantial gainful activity. It's often abbreviated to SGA. Substantial gainful activity is an earnings test, and the dollar amount changes from one year to another. But in 2022, substantial gainful activity is the ability to earn $1,350 a month, unless you're blind. If you're blind, then substantial gainful activity is the ability to earn $2,260 a month. So if your child has a diagnosed condition that prevents him from engaging in paid work that will consistently earn him either $1,350 a month or $2,260 a month, then your child has passed that test. They cannot engage in substantial gainful activity, which means they meet the statutory definition of disabled. And that's our threshold test to determine whether or not the child qualifies for SSI. So assuming that we meet that test, then your child has to pass the means test. The means test is a resource test. So if your child has less than $2,000 in non-exempt resources, then they pass the means test. So non-exempt resources are obvious things like money in a bank account. If your child has, a bank account where you've been carefully saving all of his birthday money and all of his gifts from grandparents for his whole lifetime, and you've got $5,000 in there, then he doesn't pass the means test and he's not going to qualify for SSI. And the means test will apply on the first day of every month. So even if your child qualifies for SSI and then later has some resources, if they have more than $2,000 on the first day of a given month, then they will not qualify for SSI in that month. Assuming that your child passes the means test, they also have to pass the income test. And for SSI, the income test includes both earned and unearned income. So if your child has earned income, say from a job, then that's obviously part of the income test. But unearned income includes things like child support. A lot of people don't know this, but if your child is over age 18 and you are divorced and child support is being paid for the care of your child, then Social Security will disregard the first $20 of that child support every month, and all the rest of it will offset SSI dollar for dollar. So there are some things that you might not think about as income that actually are considered to be income. But assuming that your child passes all of these tests and they will qualify for SSI, the maximum amount that you can get in SSI a month for 2022 is $841 a month. And SSI in Georgia, as in many other states, is linked statutorily to Medicaid. So if your child gets SSI, then he also gets Medicaid, which means you don't really have to apply for Medicaid. You can just get it. You can just take your SSI approval letter and go to Medicaid and say, here we are, we're here to sign up for Medicaid, and you can get a Medicaid card. So once you have SSI, you're not done passing tests and paying attention to resources, because there are all these different ways that SSI can be reduced or lost. So one thing that catches people by surprise sometimes is there's this thing that SSI pays attention to. It's called in-kind support and maintenance, or ISM. The reason that Social Security cares about this is because SSI is supposed to be for food and shelter, which means if your child is getting food and shelter from any source other than either SSI or an ABLE account, then they are getting in-kind support and maintenance. So if your child lives with you for free, then you're giving him food and shelter. And Social Security is going to look at that situation and say, well, obviously you don't need all this money that we're giving you every month because you're getting free food and shelter from some other source. So they will reduce your child's SSI benefit from $841 a month to $560 a month. They reduce it by a third every month that your child is getting in-kind support and maintenance. So the way to avoid this is to have your child sign a room and board agreement so that they're essentially renting their bedroom and they're paying you for the right to eat out of the refrigerator. So the room and board agreement should be for some amount that's less than what they get in SSI, so that you can take it to Social Security and say, look, he's paying us $500 a month to live in his bedroom and eat out of the refrigerator. That's all of his food and shelter costs right there. And that should cause them to reinstate the full $841 a month. So if your child is under guardianship when all of this stuff is happening, then of course your child can't sign a room and board agreement because they can't legally sign a contract. But that's okay, because the guardian can sign the contract on behalf of the child. So even if it's you renting the room, renting the space to your child, and you are also the guardian, you can sign on your child's behalf as your child's guardian if necessary. So remember that the means test applies on the first day of every month. So if we have more than $2,000 in non-exempt resources and we want to do something to get rid of that money, you can't just take it. Your child can't give the money away. You can spend it on anything that is for your child, but if you don't have anything to spend it on and you need to hustle up and get that money out of your child's bank account because the first of the month is coming, your two choices are: you can open an ABLE account, or you can use a particular type of special needs trust. So if we're just talking about a little bit of money, then probably the easiest and certainly the least expensive thing to do is to open an ABLE account. And the ABLE account is, it's referred to as the stable account in Ohio, and Georgia has piggybacked onto Ohio's ABLE program. So Georgia itself doesn't have its own ABLE account. They're using the one that's administered by Ohio. But the ABLE account is something you can open online. It's really easy. You can open one in 5 minutes. You can only have one ABLE account, so you can't open multiple accounts. And there is a limit to what you're allowed to contribute to an ABLE account in a given year. And that limit is the maximum amount that you're allowed to contribute, or the maximum amount of gift tax exemption for that given year. So in 2022, that's $16,000. So the most you can contribute to an ABLE account for this year is a total of $16,000 plus whatever amount your child has earned up to the federal poverty limit. So if your child has a part-time job and they make $5,000 this year, then in addition to that $16,000, you can contribute another $5,000 to the ABLE account. So $21,000 would be your limit in that example. This is not a place that you want to go out of your way to put money, because the ABLE account is subject to a Medicaid payback at your child's death. So it's a parking space. It's just a place to stick money if you need to, because all the money in the ABLE account is considered an exempt resource, and the means test only applies to non-exempt resources. So that's a quick way to get rid of a small amount of money. If your child has more money than you could put into an ABLE account in a given year, then another way to quickly get rid of it is to put it into a first party special needs trust. Sometimes you'll hear these called D4A trusts, or sometimes you'll also hear them called self-settled trusts. So a first party special needs trust, just like any other special needs trust, is a trust that holds assets in a manner that causes them to be considered an exempt resource. So if your child wins the lottery or inherits $100,000 outright, or has some other event happen, they're in a car accident and they get damages. If some relatively large amount of money comes your child's way and you're at a loss for what to do with it and you can't spend it on things that your child needs, then a way to cause that money to be an exempt resource is to put it into a D4A trust. So the last way that you can either lose or have SSI reduced is if you've got income that will offset SSI. So the child support that I mentioned is something that would be considered income to your child. That is the case even if the child support is getting paid to a parent. So if that happens, then Social Security will disregard $20. And if your child is under the age of 18, they'll disregard another 1/3 of it. If your child is over age 18, they don't disregard anything except the $20. And it will offset SSI dollar for dollar. The solution to that situation, again, is to use a D4A trust. You can't use an ABLE account in this case. That's not going to work. But if your settlement agreement provides that child support payments for your child get paid directly to a D4A trust, also known as a first party special needs trust, then it will not count as income and it will not offset or reduce SSI. So I mentioned that SSI is connected to Medicaid. A lot of our kids are on a Medicaid waiver called the Katie Beckett deeming waiver before they reach the age of 18. And then at age 18, Katie Beckett just goes away. A lot of people don't know this, and Medicaid is not going to tell you this, but it's possible to extend Katie Beckett for another year if you're in the process of applying for SSI. So you can't even submit the application for SSI until your child is actually 18. So you can't begin the process until your child's 18th birthday has arrived. So obviously, there's no way your child is going to have SSI on their 18th birthday. So for some people, the Medicaid is more important than the SSI check. I have families who have kids that are getting medications that are $4,000 a month. And if they lost Katie Beckett, it would be a disaster. So you can extend Katie Beckett if you're in the process of applying for SSI. And here's how you do it. You file for SSI. Once you've submitted the application, you're going to get something from Social Security that's called an application summary. If you give a copy of that application summary to the Katie Beckett unit, then you've documented that you're in the process of applying for SSI, and they will extend Katie Beckett until your child either gets SSI or turns 19, whichever one comes first. So Medicaid is never going to tell you that, but now you know. So kind of walking down the path of benefits here, this is not something that happens at a particular age. This is something that tends to be triggered by life events, but at some point in your child's life, they will very likely roll from SSI over to SSDI. Usually that's a good thing because SSDI is an easier benefit to keep and it's typically more money. So just a quick slide about the differences between the two. As I mentioned, SSI is means tested. SSDI is not. It doesn't make any difference how much your child has in the bank or whether the resources are exempt or non-exempt. SSDI just doesn't pay any attention to that. The maximum amount you can get this year in SSI is $841 a month. That gets adjusted every year for inflation. So it'll go up some weird random number of dollars in 2023 and in every year after that. SSDI is not a fixed dollar amount. There are two ways that your child can qualify for SSDI, and the way that your child qualifies will determine the amount of SSDI that they get. So the first way to qualify is on your child's own work record. So if your child has worked for enough years and has a work history, and then their condition gets worse or they develop another condition, they have some type of disabling condition that makes it impossible for them to work, then they can get SSDI based on their own work record. So Social Security is going to look at their earnings history and do a bunch of math, and according to their formula, they'll come up with a dollar amount that the child is qualified for. So if the child gets SSDI based on their own work record, a lot of times, because they may have enough quarters of work to qualify them, but their earnings may not be substantial enough to give them more than $841 a month on SSDI. If that's the case, then it's possible to be on both SSDI and SSI at the same time, so that your child is getting at least $841 a month. So if your child loses the ability to work and they go on SSDI, but the math works out that they get $300 a month in SSDI, then they'll still get $541 a month in SSI. So the better way for your child to qualify for SSDI is on a parent's work record. And this is one reason that it's a great idea for you to apply for SSI as quickly as you can, and certainly before your child reaches age 22. Because in order to qualify for SSDI based on a parent's work record, you have to have a disability that began before the age of 22. And one really good way to prove that your child has a disability that began before age 22 is to get them on SSI before age 22. Because if you're on SSI, that means you've met that statutory definition of disabled. So Social Security can't argue that your child wasn't disabled before age 22 if they were on SSI before that age. So assuming that that's the case, then when a parent dies or retires and begins to draw Social Security, or becomes disabled themselves and begins to draw Social Security, then the child rolls from SSI to SSDI based on the parent's work record, and they get about half of what the parent is entitled to get in Social Security. So usually that's a higher number. So if a parent retires and draws, let's say, $3,000 a month in Social Security, the child is likely to get about $1,500 a month. So obviously much more than SSI. So SSI is linked to Medicaid. So if you're on SSI, you automatically get Medicaid. SSDI is linked to Medicare after 2 years. So 2 years after you go on SSDI, you get Medicare. It's possible to lose Medicaid. I think I have a slide about this later during those 2 years, but you can also get it back. So don't worry about that if it happens. It's fixable. And while SSI is reduced by both earned and unearned income, SSDI is only reduced by earned income. So if your child is getting, let's say, a payout from an IRA or some other type of passive income, that's not going to affect their ability to get SSDI. And finally, we talked about the ISM rules, in-kind support and shelter, that apply to SSI and can reduce SSI by a third. There is no in-kind support and maintenance rule for SSDI. So you can spend SSDI money on anything. You don't have to spend it for food and shelter. So we've talked about the means test a lot, and both SSI and Medicaid are means tested, meaning if you have more than $2,000 in non-exempt resources, then you don't qualify for those benefits. And so sometimes people think, well, now that my child is on SSDI and Medicare, we don't care about the means test anymore, and it's fine for him to have resources. But this question, when can we stop worrying about the means test? It's really a trick question because the answer is never. We always care about the means test, no matter what. Even if we're on SSDI and Medicare, which are both not means tested, we still care about the means test. We care about it forever. And that's because there are so many different types of Medicaid out there. And we always want our kids to qualify for all the various types of Medicaid. So some of the ones that are a bigger deal later in life are, there's a type of Medicaid called QBT Medicaid. Medicare, as you might already know, if you're older and you're on it yourself, we all get Medicare at age 65. There's a component of Medicare that's free. And then there are additional supplemental types of Medicare. So for example, there's a prescription drug benefit for Medicare that you can get. And many people have to pay a monthly premium to get those supplemental types of Medicare. And the amount that you pay in monthly premium is determined by a formula that Medicare will apply. If your child is on Medicare, but they still pass the means test, then QBT Medicaid will pay the monthly premium for them to get those supplemental components of Medicare. It's not exactly Medicaid per se, but it's a benefit that's funded with Medicaid dollars. It's called family support. And family support is up to $3,000 a year. It's a budget that you can use to pay for anything that will allow your child to integrate into the world and live as independently as possible and have the most fulfilling possible life. So family support might pay for summer camp or pottery classes or dance classes. My son is on family support and it pays for him to have private swimming lessons once a week. It can pay for a family membership to a gym or a pool. You just have to use a preferred vendor. But family support is a means-tested benefit. It's Medicaid dollars. And it's kind of a consolation prize that you get while you're waiting for the big brass ring of Medicaid. And that would be either the now waiver or the comp waiver. Those are funded waivers that allow your child to have a certain amount of dollars every year. And it can be $60,000 or $70,000 a year if you get a comp waiver. That's the greatest amount of money you can get. And that's a budget that Medicaid gives you to pay for supported living and transportation to certain types of activities and all kinds of other stuff. Again, those waivers are means tested. So if your child doesn't pass the means test, and someday you want your child to live in a group home and have paid support, the comp waiver could pay for that, but you got to qualify for it and you have to pass the means test in order to qualify. And then finally, very far down the path of your child's life, if your child ever needs a nursing home level of care, then there's a type of Medicaid that's called nursing home Medicaid. And it will pay for a nursing home level of care. It's offset by any income that your child has. So they would look at, if your child's getting $1,000 a month in SSDI, for example, then nursing home Medicaid would say, okay, well, we think that you can pay for $1,000 a month of your nursing home. If your child is the beneficiary of an IRA and required minimum distributions are coming out of that IRA, Medicaid will say, okay, we think that you can afford to chip in that money towards the cost of your nursing home care. But anything that Medicaid determines your child can't pay for, nursing home Medicaid will pay for that, assuming that you pass the means test. So you always care about the means test. And then there are certain ages other than 18 that also tend to be significant ages. And the first one is 22. Age 22 is a really big deal because that's the age when your child no longer is eligible to get services from the public school system. So it's kind of, a lot of parents talk about it like, that's when your child falls off a cliff. That's when all the services that you've gotten for your child's whole life just go away and you have to become a cruise director. You have to build a life for your child with no infrastructure. It's something that I think about a lot. My son's only 16, but I have already started to think, what do I want his life to look like? I definitely don't want it to be sitting in my house playing with his iPad 7 days a week. I don't think that's good for him, and I don't think it's going to be a fulfilling, happy life. So there's no pat solution to this, but I've put a couple things down on this slide that are things that people often use, and often it's in combination, more than one of these things. But there are a lot of day programs out there. So a day program is just a place that your child goes during the day. And, they're often social. Sometimes they have a work component or an educational component. I am on the board of an organization called the Fraser Center that has what I think is a great day program for adults, intellectually disabled adults over the age of 22. And at Fraser Center, they take their day program participants out and they do photography classes and dance classes. They have a walking group. They have all kinds of activities. And the goal is to get them out into the world as much as possible and help them to develop skills and have fun and have hobbies. There's a very good day program at Just People. There's an excellent day program at Annandale Village. There are a number of them all around the state. So that's something that a lot of families do. For some of them do it 5 days a week. You could do it 1 day a week. You could do it anything in between. There are supported employment programs. A lot of companies have those. So, a lot of the grocery stores like Publix and Kroger have supported employment. I believe Target has a supported employment program. So remember that your child can still stay on benefits if they earn less than $1,350 a month. So, a lot of our kids will work, maybe not a 40-hour week, but maybe a 15-hour week or maybe a 20-hour week. There are also a lot of places where your child can work as a volunteer. And then finally, this last little entry, let your child find his bliss. This is what I've already started working on with my son. He's a great athlete. He loves to run. He loves to swim. He plays buddy baseball. He does a swimming class, and he's getting ready to join an adaptive swim team. When COVID has really subsided and I really feel okay about it, we'll probably use family support money to have him work out with a personal trainer. I'd love for him to work out with a personal trainer maybe 1 or 2 days a week, because I would like him to have the kind of life where he is happy and busy and physically healthy. So I want him to be in the habit of exercising every single day in some fashion. So the next, I'll just jump over there really fast and then jump back, but there's a slide coming up. Jade and I talked about this yesterday. If you're looking for resources after your child turns 22, Focus has a great resource page, and there's a specific area where you can go to look for resources that are for adult kids. And I would highly recommend that you check that out. And we're going to get to that slide in a minute. The other thing that's significant about age 22 is that, as I mentioned, this is the test age for the qualification for SSDI on a parent's work record. So if you haven't gotten your child onto SSI yet, and your child is younger than age 22, I would highly recommend that you go ahead and apply, even if you don't care that much about SSI, because someday when a parent retires or dies or becomes disabled, it would be great if you could easily demonstrate that your child should get SSDI based on that parent's work record. So another significant age is when your child turns 26. This is not true 100% of the time, but in many cases, that's the highest age that you can keep your child on your medical insurance. So for many of our kids, when they turn 26, medical insurance goes away. And the two easy solutions to that are, either be on Medicaid or Medicare, or buy a policy through Obamacare. And it's great that you have that option, but those policies are not especially cheap. So the most affordable way to provide your child with medical coverage after age 26 is probably going to be Medicaid or Medicare, just depending on what other benefits your child is on. And this is the way you can get to that Focus page of resources that I mentioned. Go to the Focus website, and they have a little tab that says how we can help you. And then you click on Hope, click on resources. And one of the resources is, it says transition to adult services. And that's where you can find a nice list of options to look into if your child is over 22 and you're looking for ways to help them have a nice, busy, happy life. And then there are some other things that happen. They just happen in life. They don't happen at any particular age, but they're triggering events, and I wanted to mention them in this talk. So one of them we've already talked about some. It's the death, disability, or retirement of a parent. If your child is qualified, they'll shift from SSI to SSDI. With the loss of SSI comes a loss of Medicaid, but you can get it back. If the only reason that your child has lost Medicaid is because they've moved from SSI to SSDI, then you can apply for another classification of Medicaid. It's called the Adult Disabled Child category of Medicaid. And you can carry on the Medicaid coverage while you're waiting out that 2 years until they go on to Medicare after they start SSDI. Another big triggering event that people don't necessarily know will be a triggering event is if your child gets married, that is going to have a huge effect on your child's ability to get benefits. So if you are married and both halves of the married couple qualify for SSI, they have a different means test than a single person does. So the means test for a married couple is not twice the means test for a single person. It's $3,000. So if your child gets married and they marry someone who also qualifies for SSI, all of a sudden, the two of them together can't have more than $3,000 in non-exempt resources. The SSI amount also goes down by 25%. So if your child is married, again, to someone who qualifies for SSI, then the married couple is considered a unit as opposed to two individual people. And the maximum amount they can get is $1,261 a month. Also, if your child gets married, they no longer qualify for SSDI based on a parent's work record. And finally, if your child is married and you're contemplating guardianship, then statutorily, the first person in line to be considered as a guardian is the spouse of the proposed ward. So that doesn't mean that your child's spouse is automatically going to become a guardian, but you're going to need to have an explanation for the court as to why your child's spouse shouldn't be the guardian. And that might be really easy. The explanation might be because my child's spouse is intellectually disabled and they don't have the capacity to serve as a guardian. But it's something that you would need to address if guardianship is at issue. So that is everything I have, except that I wanted to mention that I'm doing another workshop in a few weeks. This is through Special Needs Cobb. And this workshop is going to be all about special needs planning. So that's happening. I just wanted to mention it. And I believe we are ready for questions. I'll just leave this up in case anybody wants to note this down.
Thank you, Kim. I am adding your cheat sheet of resources to the chat box now. So anyone that wants to check that out can certainly click on the link. So the first question that you have in the chat is, are you able to get this presentation sent to us through email? So this recording will be available either tomorrow afternoon or Monday afternoon on the Focus website. Same spot where Kim mentioned the resources. If you go to how we can help you under Hope, there is a category for workshops. Second question. My understanding is that in Georgia is that you can't get food stamps until 21.
I know a 19-year-old who has SNAP benefits. I think that I've heard this. I've heard people say 22. But I mean, I know that you can get them. And in fact, I looked this up on the website because I wasn't totally clear on whether there was something significant about age 21 or 22 or whatever. But according to the website, you technically qualify once you're a household of one, which is when you turn 18. My guess would be that the logic in denying somebody SNAP benefits before age 22 might be that 22 is the age where you don't qualify to get services from the public school system anymore. And if you are getting services from the public school system, one of the things that you're entitled to get is free and reduced lunch. Nobody has ever told me this. This is just me guessing, but I am guessing that possibly in some cases, people might be denied SNAP benefits because they're entitled to free and reduced lunch from the public school system till age 22.
Thank you, Kim. The next question is the child considered waivable if still in school?
Waivable? I am not sure that I understand what that question is asking.
Amy, if you can kind of give us more detail about that question. Question from Suzanne, how do you register your child to vote who is a ward or has a guardian. If you go online, it asks you to have been declared by a judge, and if you check yes, it won't let you register.
Well, when you are awarded guardianship by the court, the first thing that you're going to get before you even get your letters of guardianship is an order from the court saying this person is incapacitated and they need a guardian. And that order should say, these are the rights that we're removing from the ward. And if that order doesn't say we're removing the right to vote, then the child retains the right to vote. So I have never tried to register a person to vote online who is under guardianship. It's possible that you may need to call voter registration and they might want to see the order, but the court order creating the guardianship should say whether or not the right to vote has been removed. And if it hasn't been removed, then it has presumptively been retained.
Thank you, Kim. Is my child eligible to apply for SNAP if he or she is getting SSI and has a room and board agreement?
Yes.
Thank you. Might I need conservatorship if my child gets a paying job, but the paycheck goes directly into a first party trust or an ABLE account?
The paycheck is not going to go directly into either one of those things because this is an IRS rule really, but no employer is going to pay your child. They have to pay the child directly. So they could pay the child in a bank account with the child's name on it, and then that money could go from the bank account to an ABLE account or to a first party special needs trust. But the payments are not going to go directly to any place except to an account with your child's name on it.
Thanks, Kim. How do you create a trust or guardianship if you don't have a specific person to act as a guardianship after we are gone?
Well, as I mentioned, I think when I was talking about the guardianship issue, guardianship doesn't go away because the guardian can't do that job anymore. So once your child is declared incapacitated, they're incapacitated until the court says that they're not. So of course, if you're not around to be your child's guardian, somebody else is going to have to do that job. When I do estate planning with families that have a child under guardianship, we always nominate a successor guardian under the will. So that's just a nomination. The court is the entity that will decide who the next guardian is, but they do give a lot of weight to your nomination of somebody to be the guardian when you're not able to do that job anymore. And as far as the trusts go, a trust has a trustee. That's the person whose job is to take title to the trust assets on behalf of the trust and manage those assets and distribute them as needed. So in the same way that you can name somebody to be a successor guardian, when you create a special needs trust, you absolutely would nominate as many people as you have in succession as successor trustees. And it's a good idea to end your list of successor trustees with an entity like a bank because they don't die. So we'll never run out of trustees, even if we run out of people.
Thanks, Kim. Where can I find info on family resources? Maybe she means family support.
Family support. Depends what county you live in. If you live in Clayton, DeKalb, Fulton, Gwinnett, or Rockdale, then what I would do is call the Bobby Dodd Institute because the Bobby Dodd Institute manages the family support pot of money for those counties. So again, those counties are Clayton, DeKalb, Fulton, Gwinnett, and Rockdale. So I don't have this up on a slide, but I think it's bobbydoddinstitute.org is the website. You can just Google Bobby Dodd Institute and you should be able to find it. If you don't live in one of those counties, you can just Google, look up family support in, and then whatever county it is. So every county has some entity that administers family support, and they can tell you what you need to do to apply.
Thanks, Kim. Can you apply for guardianship yourself in all the counties in Georgia, or are there any counties that are where hiring a lawyer is required?
You are never required to hire a lawyer. You can always do it yourself. And the place to start would be to go to gaprobate.gov, which is one of that website is listed in the resources.
Thanks, Kim. Another question is, I just applied for SSI for my 18-year-old son. They were adamant about me not applying for food stamps first.
I don't know why that is. But if it makes Social Security happy for you not to apply for food stamps first, then I would say don't apply for food stamps first.
You got some compliments like thank you and the workshop was informative. And then another question that we have is, can we add more than one person in the guardianship?
You can petition for people to be co-guardians. So sometimes both parents will be co-guardians. I mean, that happens all the time. Or sometimes if the parent is older and there's a sibling that they want to do that job in the future, sometimes I'm actually doing one of those right now. We're petitioning for the father and the sister of the proposed ward to be co-guardians. So they'll do the job together while the father is still able to serve. Just one thing to keep in mind if you do petition to be co-guardians is that if you are a co-guardian, the court expects you to act as two halves of a whole. In other words, you can't say, you take this job and I'll do that job. This comes up the most often if you've got a situation where your child needs medical treatment. They don't always do this because doctors are doctors and they're not lawyers, so they just want to take care of people. But what they're supposed to do is they're supposed to say, oh, this child has two guardians, where's the other one? Because your job as a guardian is to consent to medical treatment on behalf of your child. So if your child has two guardians, a doctor could and should really require that both guardians be there to consent to medical treatment. So it's your call whether you feel like that's going to be burdensome, but you absolutely can petition to be co-guardians.
Thank you, Kim. And then our last one is a thank you. This has been really helpful and that they appreciate you. So that's all of our questions today, but we just appreciate your time and your knowledge. And of course, not only do you know it all professionally, but you know it as a mom too. So we just appreciate that. And if you can pull up your next slide again so that everyone can see your contact info.
All right, there it is.
So if anyone would like to reach out to Kim, her email address is kmartin@harrisonheld.com. Kim, thank you so much for today, and we look forward to seeing you again soon.
Okay.
Thank you all. Have a great day.
Thanks, Jade.